Hello everyone, this is Heidi Slater with CEB, and this guide is going to walk you through the forms you need for a petition under new Probate Code Section 13151. This procedure allows you to collect a decedent's primary residence without a probate if its value is under a certain amount. You'll need 6 judicial counsel forms: DE 300, DE 310, DE 315, DE 120, and DE 160 and 161. We'll start with DE 310, the petition itself. You'll fill out the caption information as you normally would in any probate action, and that goes for all of the forms in this procedure. At item 1, you'll start by inputting the name of the petitioner. The petitioner will either be the beneficiaries of the property if the decedent had a will, or if the decedent did not have a will, the people who succeeded to the property under intestate succession laws. You'll need to indicate which of these 2 types of petitioner your client is in the appropriate box of item 12. That's actually on page 2, but just make a note of that for now. At item 2, fill in the decedent's name and date and place of death. Note that, as shown here in item 3, you have to wait until 40 days have passed from the decedent's death before you can file the petition. At item 4, tell the court whether the decedent resided in this county or if they resided outside California but owned property in this county. Then at item 5, mark whether the decedent died with a will. If they died with a will, you'll need to attach a copy of it to the petition. For items 6 and 7, you'll need to confirm either that no probate has been opened for the decedent, or if one has been opened, that the personal representative consents to the petition. In that case, you'll need to attach a copy of the written consent to the petition, and you'll also need to provide the case number and court information for that probate matter. For item 8, you need to confirm that the property satisfies the value limit that applies at the time of your decedent's death. The different dates and values are listed here in item 8, and you'll need to support your value with an attached appraisal from the probate referee, and we'll touch on that in a bit. So for items 9 at the bottom of page 1 and 10 at the top of page 2, you're checking the appropriate boxes about who the decedent was survived by. This helps the court determine who is entitled to the property and who is entitled to notice of the proceedings. So review those boxes and check the appropriate ones for your situation. Item 11 is the meat of the petition, and you'll be completing this item by using an attachment. You're going to provide the court with the property's legal description and APN, the nature of the decedent's interest in the property, and the facts establishing that the property qualifies for a 13151 petition. So basically, you're showing that the property is in California and was the decedent's primary residence. Note that under Probate Code Section 13150B2, the term primary residence is not limited to the decedent's residence at the time of their death, so keep that in mind. If the decedent died without a will, you're also going to need to allege here facts about whether the property was community or separate property. So we already touched on item 12 earlier, which is where you're checking that box about which type of petitioner your client is, either the beneficiary or heirs under intestate succession. For item 13, describe the interest each petitioner has in the property. For example, is this one person who will succeed to all of the property? Is this a property to be held in trust? And if so, on what terms and for whose benefit? All that sort of information goes here. For item 14, you're providing the court with the names and other identifying information about the petitioner, the people who you checked up in those earlier boxes, 9 and 10, as being survivors of the decedent, and any other people who are or may be entitled to inherit the property. In item 15, you'll also include the executors named in the decedent's will if they had a will. If the petitioner is a trustee of a trust, you'll need to check the box in item 16 and identify all persons with an interest in the trust in an attachment. Otherwise, you can skip this item. Finally, if the decedent was subject to a guardianship or conservatorship, you'll need to complete item 17, identifying those guardians or conservators. And then, of course, once you're ready to file the petition, you and your client will date and sign at the bottom. Okay, so what forms must be attached to the petition? First is DE 300. This is the form that lists the applicable value limits for all the different small estate procedures. There's nothing you need to fill out on this form, just attach it to the petition. Second, you'll need to attach an inventory and appraisal, or INA, showing the value of the residence. These are forms DE 160 and 161. You'll fill out part of these forms and the probate referee will fill out the other parts. So we'll start with what you fill out. Beginning with item 3, under the declaration section, you'll indicate whether this INA covers all or only a portion of the assets in the decedent's estate. You'll skip item 4 because you are having a probate referee appraise the property. At item 5, you'll check box 5B to confirm that you filed a change in ownership statement, and do be sure to file that as you normally would with real property. Your client will sign this section. In the statement of bond section, items 6 to 8, check and complete the appropriate boxes depending on your situation. You'll be the one signing this section. And the last part of the form that is your responsibility is the attachment listing the primary residence. You'll use form DE 161 for this. Because we're dealing with real property, you'll label the attachment Attachment 2. As a reminder, Attachment 1 covers cash and cash equivalents, and Attachment 2 covers all other assets, including real property. On this attachment, you'll describe the property in the left-hand column. This means the address, APN, and legal description for the property. Now, the probate referee will fill out the remaining parts of the form. On DE 161, that includes items 1 and 2 on page 1, which total up the appraised property on the attachments. They'll also fill out items 9 and 10 on page 2, which details the referee's commission. And on DE 161, the referee will fill out the appraised value of the property in the right-hand column. They'll then send the completed form back to you, and together you'll file that DE 160 and 161 as attachment 8 to your petition. So that's our petition itself, ready to file. The last 2 forms that you'll need to complete the process are our proposed order and notice of hearing. The order uses DE 315. You'll fill out this form as completely as you can and submit it to the court when you file the petition. You can't complete item 1 yet because you'll need the hearing date from the court, so skip that for now. Complete item 3 with the decedent's date of death, their connection to this county, and whether the decedent had a will. At item 5, you're checking the box as to whether no probate has been opened, or if one has, that the personal representative has consented to the petition. At item 6, you're checking the box for which value limit applies to your situation. At item 7, you're again checking which type of petitioner your client is, so whatever you checked in item 12 of the petition itself, you'll check the same box here. At item 9A, you'll need to provide the property's APN and legal description, and at item 9B, each petitioner's name and interest in the property. So this information is all pretty duplicative of what you gathered for the petition itself, so you should be able to complete these portions fairly quickly. And that's all you need to do for that form. Okay, so you filed your petition and submitted the proposed order to the court. Now what? The final step is the notice of hearing. For the notice, you'll use DE 120, your typical probate notice of hearing form. In item 1, you'll list the petitioner's name and any capacity that they're filing in, such as trustee. And right below that, you'll list the title of the petition, which is Petition to Determine Succession to Primary Residence. Skip the box at the bottom of item 1 because it does not apply. You'll have to wait to fill out item 2 until you get the hearing date from the court, which is one thing I want to note. Probate Code Section 13151B requires that you give notice of the petition within 5 business days of filing. This means that if you don't receive the hearing date from the court right away, you may need to send notice to everyone twice, once to comply with the 5 business days rule and a second time to notice them of the hearing date. Okay, moving on to page 2. You can skip the top portion regarding the clerk's certificate. Below that is the actual proof of mailing. You'll fill this out like you would any other notice of hearing. The server's address in item 2, the method of mailing in item 3, the date and place of mailing in item 4, and in item 5, you'll check whether you served a copy of the petition itself with the notice. Beneath all that will be the server's name and date of signing, and their signature once the mailing has been done. The final section at the bottom of the page is the list of the names and addresses of all people you served. You'll need to provide notice to all persons listed in the petition pursuant to Probate Code Section 13152A7. Once service is complete, be sure to file this notice of hearing with the court to avoid any delays. And that is it. We hope this video will be helpful when preparing your petitions under the new Probate Code Section 13151.